Well, here.
All right.
The phone number ending in 78. Can you please identify yourself?
No, that wasn't audible. I could hear sounds, but not words.
You guys want Modelo's?
Are you appearing on screening order?
Sounds like background noise of some kind. It doesn't sound like someone addressing us.
No. The phone number ending in 87. Can you please identify yourself?
Okay.
Well, they're going to get muted.
All right.
Presumably they are not. It's Jessup.
Oh, and we took Murray off. That's got postponed. Okay, I'm gonna put this away. Till when?
May 6th.
Oh, that's a ways out. Okay, I'm gonna put this away then. Do we have the parties we need for Bong and DOJ?
Yes, Your Honor, I believe you do.
I am here on behalf of DOJ. This is Tracy White.
And Jill Bong, I'm here as well.
Okay, give me a second here. So if we have the necessary parties, we'll just take that first and deal with the Jessup matter afterwards. Okay, that's fine. Give us just a second here. Making sure I've at least got everybody. Okay, so I have Ms. Bong and Ms. White, right?
Yes.
Yes.
Okay. All right, that's who we were after. Okay, so I will say this is Bong versus Oregon Department of Justice and Oregon Attorney General, 23 CV 45434. This was the time set for a hearing regarding the motion to strike, I believe. Give me a second here. Yes, and to address the defenses that were raised in respondent's answer. Is that what we still need to have the hearing on?
Yes, Your Honor. And also, Ms. White and I could not come to agreement on some of the stipulated facts that are necessary for my closing arguments. So if the court has time after our strike hearing, I don't know if the court would be able to perhaps help us hash that out.
Maybe a little bit, but we do have a trial starting today. We could set another date to to do that. We probably have time. It's just we are currently scheduled for a trial at 9:30, so I don't want to promise anything.
Understood.
That said, regarding the motion to strike, I understood that this would be legal argument only. We're not going to be getting into any facts because it would be a legal motion to strike.
That would be correct. Yes.
Okay. All right. Well, if the parties are prepared to do that, Ms. Bong, I'll go ahead and have you go first and argue your motion to strike.
Okay, thank you, Your Honor. So any cases that I cite are briefed in the court filings, so I'll leave the court to look that up. And so my basis for the strikes are under ORCP 21A to B factual basis, the grounds on which any of the enumerated defenses are based must be stated specifically and with particularity in a responsive pleading or motion. And according to Johnston v. Brayhill White Pine Company, 1933, the facts constituting each defense should have been set forth so that the court could have determined whether they were sufficient for that purpose. So now I refer the court to respondents' defenses, and that would be defense 1, 2, and 5, which were only stated as one-sentence defenses. And on that grounds alone, I'm moving the court to strike those as being insufficient and not stated with specifically. I'm sorry.
Sorry.
And that would be under ORCP 21E. Insufficient pleading. E2 would be the basis for an insufficient defense. With regards to, let's see here. I'm sorry, I'm looking at her defenses here.
I believe you addressed number 4 at least.
Number 4 is, let's do the number 3, which is the Tort Claims Act, which I moved to strike as being, I believe it was, no, let's see, I'm looking at number 3 here. It was a sham defense because they're alleging that my claims are subject to the Tort Claims Act, but the Tort Claims Act, ORS 30.260 subsection 8 says a tort is a breach of legal duty that is imposed by law. But my basis for this proceeding is that the respondents are acting out of scope. Acting out of scope is not a breach of legal duty, and therefore the court should strike this defense as being a sham. Finally, the 4th affirmative defense, which is the forum non-convenes. I'm sorry, I'm not quite sure how to pronounce the last word there.
Okay.
I believe it's an inconvenient forum is what the respondents are referring to. And once again, it's an insufficient defense and it's not separately stated because counsel or respondents have asserted that the issue has been raised in the federal court. Now, these are 2 issues that are not separately stated because an inconvenient forum states that, from my research, that it states that this court has jurisdiction over the case, but there is a more convenient forum. And from all my research, that means that the case can be moved to an out-of-state or foreign country, which does not apply in this case whatsoever. With regards to the issue being raised in federal court, I have raised a motion to the federal court asking the court to stay proceedings by the respondents with regards to their defense for Brown and Banks in their individual capacity. And that was raised under ORS 9.350. This is not in the pleading itself, I don't believe. 9. 8.350 states the court or judge thereof on motion of either party and on showing reasonable grounds therefore require the attorney for the adverse party to prove the authority under which the attorney appears, and until the attorney does so may stay all proceedings by the attorney on behalf of the party for whom the attorney assumes to appear. That motion was denied by the federal court. Regardless, that's all that was raised in the federal court. There was no trial, and the court has no subject matter jurisdiction over this issue. And also, the respondents are not parties in that case, and therefore the court also does not have personal jurisdiction over the issue. And therefore, I'm moving to strike on the fourth affirmative defense.
Okay.
And I think we've covered them all.
I believe so. Was there anything else?
I don't believe so. I guess I can respond to Ms. White if she has any arguments to that.
Yep. Okay. And Ms. White.
Thank you, Your Honor. I've kind of set out, my thoughts in our response brief, but just to kind of summarize them, we have 5 affirmative defenses. I've already stated to Ms. Bong and also in our brief that we will pull the first one. So I'll file a amended answer to affirmative defenses. But as far as the other goes, failure to state a claim, that's taken right out of ORCP 21. And in this case, we think that plaintiff's brief literally, her complaint literally fails to state a claim because it's raising a legal argument that is incorrect. And so I think, whether or not that will prove to be the court's ruling, is a matter for a later time. But right now, as an affirmative defense, it seems fine. It seems like that would just be fine. That's literally what we're saying. Again, this is not the time when the court would rule on these motions or these defenses. So it should be appropriate. Oregon Tort Claims limitations, as I cited in my brief, there is authority for an Oregon Tort Claim requirement to apply to a case such as this one, declaratory judgment. And while the plaintiff thinks of some facts that might disprove this, that's a factual question, and so that's not the place for to challenge an affirmative defense. Forum nonconvenience, that's a principle saying that the court could decline to hear a case. I don't believe it only applies to foreign places. I believe it applies wherever, and it's a discretionary standard. And as I have pointed out in my brief, it's the court's discretion to decide whether or not that should be left to another court. In this case, the federal court. And that's spelled out in my affirmative defense. Again, the plaintiff disagrees with this on the merits, I guess, but that's not the time and place to rule on whether or not the affirmative defense is okay. And also we have standing, which is basically that the whole issue in this case is that plaintiff believes that a couple of the defendants in the federal case, or maybe in general, don't have the right to have an attorney general from the DOJ to defend them, but that's not her place to be challenging that because it's not her attorney or her particular issue, and that's directly what standing has to do. So again, while plaintiff may challenge all of these things based on the facts as affirmative defenses, they're fine and appropriate, and the court should reject the motion to strike those.
Okay. So you said that your first affirmative defense is being withdrawn anyway?
Right, and that's what I have told Ms. Bong, and also I have put that into the brief that we responded to, which was estoppel. Yeah, and I put that in the brief, but also I've told Ms. Bong that, and also I believe she knows that because she didn't argue that one, so I think she understands. I think we all are in agreement there.
Okay, and all right. So the forum nonconvenience is, you're saying that the court simply has discretion on that, rather than that it would be compulsory.
Correct. And again, I don't think we're here to decide for you to decide whether or not that's a good defense right now. It's just that it seems like it's appropriate to put in the answer.
Okay.
Yeah.
Okay, I understand.
And let me just clarify here, I believe it's discretionary. I guess I could be wrong on that, but it's my understanding of it.
Oh,
I
yeah,
believe
no, I'd
it is
have to look it up.
discretionary. Yes.
I don't know off the top of my head. Okay. And then the Tort Claims Act limitations is, you're saying that whether the Tort Claims Act limitation would apply would be a matter of fact to be found. Is that right?
Oh, that's correct. And I believe Ms. Bong agrees with that because she was saying, well, I'm saying that people aren't within their scope of employment or some such, which sounds like a fact issue to me.
I understand. Okay. And okay, not having standing.
And again, I don't think anyone's asking you to decide if these things are correct or true or right. It's just whether or not they can exist in the answer.
Yes, no, I get that. I'm just looking to see if, because the thing that I am concerned about really is that second affirmative defense. Petitioner's claim for relief failed to allege ultimate facts necessary to state a claim, whether that is sufficiently specific and particular enough. Okay, that may be what I'd have to look at, because I don't know what the case law is as far as how specific and particular something would need to be at a minimum to survive a motion to strike, because I probably do need to look at some case law, because that one does strike me as being very brief and without much detail. Whereas lack of standing, I understand. I mean, there's only one way to not have standing, and that's to not have standing. Whereas the failure to allege ultimate facts necessary to state a claim, there's a lot of different claims. So I'm, yeah, that's the one that's hanging me up.
Right. And Your Honor, I believe failure to state a claim is not really even technically an affirmative defense. I think failure to state a claim is generally just like, we think you're wrong. It's kind of a fancy
Yeah,
way
no,
of
I get
saying
that.
it.
I get that. And so you're saying it may not even be necessary as a defense, but rather it is just stating something that would be argued anyway.
I think so. And it's hard to know how you'd make it more specific without writing like a summary judgment brief, because we think her claim is just not supported by the law and is just wrong. And so we'd have to kind of,
Okay.
if you want, yeah. So.
No, okay, I understand that. So I may need to think about that one a little bit. Okay. Ms. Bong, you wanted to address the statements that Ms. White made, if you do.
Yeah, so Ms. White says that failure to state a claim is appropriate, and I moved to strike not only because I don't think that was stated with enough specificity in that. I mean, one line is just insufficient in my argument for that, and also that was the it's also it is also my contention that it is a sham argument, because for a petition for declaratory judgment, all that a petitioner needs to have is a controversy, an actual controversy in the case. You don't have to state a claim, because I'm not asking for damages. When you state a claim for a cause of action, you have to state a certain elements so that to suit that cause of action. So, for example, in a breach of contract, you have certain elements that you have to meet. But this is not the issue here. This is the issue involving facts of whether the DOJ has the authority to represent Brown and Banks in their individual capacities in my federal case, and therefore impeding on my judicial proceedings in the federal case.
Well, fair enough, but in this case, the failure to state a claim, you are requesting some type of relief, even though it may not be cash money or something that is a physical thing in terms of damages, but you're asking the court to do something for you in terms of relief. So you would need to have some kind of cause of action to get the court to do something for you. And that was what I understood her to mean, or that's what I understand that phrase to mean, state a claim. Is that you are saying, hey, the court can do something for me because this is the situation. That was how I understood that. Not that it was a technical phrase to get to some kind of monetary damages.
Right. but you don't have to state a claim for a declaratory judgment case, is what I'm trying to say. It's so the court may hear an action for declaratory relief is if there's a controversy and the court has subject matter jurisdiction over the controversy, and that's Brown v. Oregon State Bar. So in this case, there's no need to state any claim, so to speak, in terms of
Well, except that the stating a claim would still need to give the court some kind of basis to have a controversy, like you say. I was reading that maybe more vaguely than you are, where state a claim means to have a legal right to action rather than necessarily to have a claim for some particular relief. But if you're asking for relief at all, surely you would have to have a legal basis for asserting that you have a right to that relief. And that was how I was reading state a claim. I wasn't reading it as narrowly as perhaps you were.
Understood. Yeah, and if that's the case, if that's the way you're reading it, Your Honor, then even still, one line I don't think is sufficient. I'm not sure how.
That's what I'm going to be looking
Right.
into is how is the specificity and particularity of that, and whether it meets the standard or if it needs to be addressed further, because I would presume that that the state would request that if one of the defenses is found to be faulty and is needing to be struck, that they would have leave to amend to correct and make it more specific and particular. Is that a fair guess?
Yes, I have no objections to an amended
Okay.
Defense.
Well, and actually, I was asking the state, but yes.
No, and Your Honor, if
That's
I
all
could just say something, I'm not sure how it works here. I tried to raise my little hand on this Teams thing, but I'm not sure if it goes to you or not. But I would just say that to a certain extent, this whole thing especially as to the failure to state a claim is kind of, I think, kind of a pointless exercise, even if it's interesting if you do some research or whatnot, because we're all agreed that we're going to write, these, like, whether we call them trial briefs or whatever. And so to make the failure to state a claim more definite, what I'd have to do is basically put all my points for this other thing in there, and it just seems like a pointless exercise that is just taking up, not accomplishing
And
anything.
I guess I would note that if the court in receiving the information from the parties determined that there was in fact for Ms. Bong standing to state a claim against the state, and that claim was legally valid, that the whole idea that she had not stated a claim would be found like that would be a no on that defense didn't work, because the court found quite the opposite, that there was in fact a claim stated and that her relief should be granted in one way or another. So I don't know that I would need to rule on that ahead of time, because in the contrary, if Ms. Bong's case was legally insufficient from the very beginning, like it's just not something that the court would recognize as a claim, that it wouldn't need to be a defense, because the court couldn't then grant relief on the basis that she had not stated a claim. So it would be something the court would have to find sua sponte if it were clear, or if it turned out that there was no such legal claim on the part of Ms. Bong. So I'm not sure. I guess maybe I would say my inclination is to agree that second affirmative defense isn't striking. It would have no effect, it seems, because the court still has to analyze whether there is in fact ultimate facts necessary to have that claim. And if there isn't, the court can't find in favor of Ms. Bong. That wouldn't need to be a defense at all. It would be something that would just be the entire summation of the argument, I presume.
That's what I think, Your Honor.
But Your Honor,
Ms. Bong,
go ahead. If the respondents do have a some kind of argument that I have failed to state claim, then I could potentially amend my pleading to add those to correct those deficiencies before closing arguments.
Okay. So my understanding of the second affirmative defense is what Ms. Bong is claiming against the respondent is not something that the court can find in her favor from the very beginning. Like, even if it's 100% true, the court cannot find in her favor because it does not constitute a legal claim. Is that a correct summation of how that should be read?
I think, Your Honor, to the extent that she's asking for something, it's not that we're challenging at this, particularly the facts, it's that she's asking for a statute to be interpreted a particular way that is not
Okay.
how it can be interpreted, and therefore it doesn't state a claim. I'm not sure how else to say it.
Uh-huh. Okay. So, Ms. Bong, it sounds like the state is requesting the court kind of read that defense as the statute that Ms. Bong is suing under does not mean what she thinks it means or does not mean what she states it means, and she does not prevail based on her reading of the statute or what she's asserting. At least that's kind of how I'm hearing that. So you're amending your claim. It doesn't sound like would make any sense because they're saying you can't sue this way at all. And your argument would, of course, be I can sue this way because the law agrees with me.
That I would agree with that. Yes.
Okay. So I guess with that understanding, I'm not really going to address that second affirmative defense because failure to state a claim would be something the court would have to find on its own anyway. I have to find that there is a legal claim in order to make any award in Ms. Bong's favor. So it is sort of a redundant aspect that it doesn't need to be addressed directly by Ms. Bong as a separate defense. I would say that it needs to be addressed by Ms. Bong in general because she has to prove she has a claim that is valid. You would have to lay down a claim that's valid, and they're going to argue, I presume, it's not a valid claim because the statute means something else. And that would be what the court would be asked to decide in terms of that second claim.
That sounds fair, Your Honor. So in that case, a
Okay.
strike would be appropriate, right? Because in effect, it doesn't affect the case, the arguments anyway. So I won't have to address that directly in my closing arguments.
Ms. White, does that seem reasonable?
That it
Since
should be
she is
stricken?
having to, she has the burden of proving she has a claim and that
Right.
claim is valid. And so that she didn't state a claim as an affirmative defense is unnecessary because her burden is already to show that.
Well, yes. No, just Your Honor, I'm looking at the rules of civil procedure here because that's what
Okay.
we're talking about.
Yep.
And I'm looking at ORCP 21G3. And I'm sorry, Ms. Bong, you probably don't have that as handy as I might, and it does say a defense of failure to state ultimate facts constituting a claim, and then it has other defenses, may be made in any pleading by motion for judgment or at the trial on the merits. And so it does.
Okay.
So I might be wrong when I said it's not something you have to allege. I think maybe you do kind of have to allege it, although you could even make it at the trial and the merits or whatever. I think it's kind of one of those thing that's kind of also an issue. But in this particular case, I'm just not sure. Like,
it's so inherently pervasive in the case. That's what I'm not really sure how to address it. I guess what I'm going to do is I'm not going to strike it, but Ms. Bong, given that you have to establish a basis for your claim to begin with, I would expect the argument in effect against that second affirmative defense to be kind of throughout your closing, to the point where addressing it separately would be maybe discretionary to you because they're saying, well, that's not a legal claim. You have to establish as a legal claim anyway. I'm not sure that really prejudices you to have that failure to state a claim second affirmative defense in there because it doesn't really change what you are required to argue.
I have to raise the point, Your Honor, that in a general case for failure to state claim, the opposing party is supposed to state with particularity what exactly is deficient in the claim. And then that way the petitioner or plaintiff can then rebut. And in this case, counsel is leaving the entire very general failure to state claim on me to rebut without giving me any idea of what exactly they're trying to state, because failure to state claim can be waived if not raised at um, an early enough time in the proceeding. And I don't have that right in front of me, but it is a defense that can be waived. And if they're not giving me sufficient notice on what exactly my failure to state claim is, it can be waived.
I'm not sure that it can be waived because it says you could raise it as late as trial itself.
Let me look up.
Yeah, I'm not sure where. I don't know how the
RCP
court could
21
award
G3.
G3.
21 G3, yeah. 21 G3. The defense of failure to state ultimate facts constituting a claim, then has some other kinds of defenses, may be made in any pleading permitted or ordered under Rule 13B, or by a motion for judgment on the pleadings, or at the trial on the merits. So I stuck in a couple of those ors, just but it says you can make it at any time, and so I guess I just
Correct.
like it.
So even striking it would really have no effect because it can be raised in her closing argument regardless of whether it was stated as a part in her answer. Because, yeah, failure to state a claim is so intrinsically necessary. You have to have a legal case in order to win your legal case is kind of the way I would understand that.
Okay, so it does say that it could be raised at trial. So in that case, then Ms. White can raise it at trial, which would be the closing arguments. So in any deficiencies that I plead in my closing arguments, then the failure to state claim defense, Ms. White may raise it in her reply, and then I can respond, and then I can argue.
That's correct.
Okay.
Yes, that is exactly how I would read that. That yes, she can raise it in her closing, regardless of whether it was in her answer, which it is. But even if it were not, she could raise it in closing, and then you would have the ability to rebut that and answer her assertion that, hey, this isn't a legal claim.
Okay.
Because that's the order it goes in. You'll submit your closing, she does hers, and then you do your rebuttal closing. That is how we have it set up, right? I mean, that was what we were talking about.
Yes.
Ms. White?
Oh, yes, that's right, Your Honor. I just don't think that changing it now or trying to put in my various reasons for why this claim is not right is helpful, since we're just going to be doing that after a while.
Yeah, so I'm going to, so the second affirmative defense, I'm not going to strike that. I don't think it really does anything to strike it anyway. And I understand there's going to be an amended answer submitted.
Yeah, I can just take out that estoppel argument. I can just take out that
estoppel argument's going away.
Yeah.
Okay, and then forum nonconvenience, and then standing. Yeah, I mean, I'll look up a couple things on standing, but yeah, that would be an argument that they can make. And actually, that's specific enough, because not having standing, there's only one way to not have standing or versus have standing. One is either entitled to raise the issue or one is not. I'm not sure how you would make that more particular or specific.
Okay. So, Your Honor, I have actually responded to all of the respondents' defenses in response. Yes. So would you like me to repeat those responses in my arguments, or should I just reincorporate that?
Okay. So when you present, you're talking about in your closing argument.
Correct.
So your closing arguments, as I would normally expect to see it if it were after trial, would be, you present why you should prevail. Then the defense will present why you should not and their defenses. And then you have a response time, that I guess I would say rebuttal, where you would answer their affirmative defenses. That's how I would normally expect to see it. How you actually do it is entirely up to you, because I'm not going to be there to, coach you or anything like that.
Right.
Nor would I. But that's what normally occurs in a closing, is that the plaintiff puts on their argument for why they should win. They may or may not address the predicted defenses up front. That's more a matter of style than anything, I think.
Okay. Understood.
Okay. All right. And so I'm looking to see if I have addressed. No, I haven't addressed absolutely everything yet, have I?
I think you have, haven't you?
Okay. Wait a minute. Yeah, maybe. Okay. So that one's okay. The rest of it gets decided kind of after trial. Yeah. Or there is some factual stuff. So as far as trial, and we were talking about the stipulation to facts. I understand there are some facts that may not have been stipulated to. Is that what I heard?
That is correct.
And Your Honor, I have been thinking about this a little bit. If you, I know you got a trial at 9:30. You want to go off to that and we should talk later? I don't want to mess you up.
Well, we can set another hearing, like a status check, to review whatever it is that the parties haven't quite hammered out in terms of stipulated facts, or if we need an actual contested hearing on a factual basis.
Yes, Your Honor. That is actually a crucial argument in my closing arguments. It's one of the facts that respondents are not stipulating to.
Oh, okay.
And it actually requires potentially a discovery as well. So.
Well, I disagree with that, Your Honor. So maybe another short hearing, if,
yes.
And I'm sorry to keep bothering you.
No, it's all right. Because these short hearings can sometimes prevent an incredibly long trial. So
yeah.
I have no problem with doing that. So what I'm looking at is about a week from today. That'd be Thursday, the 25th in the afternoon. Would the parties be available?
That looks good to me.
That should be fine. Yes.
Okay. And it looks like if we set it at 3:30, I'm correct in seeing that empty for us. Like 3:30 in the afternoon, we'd be able to reserve till 5 in the event we needed it, but I'm hoping that we wouldn't need an hour and a half.
Oh, I should hope not.
Yeah, but we could make that time available in the event something needed to be discussed further. So are we okay with the 3:30 on the 25th?
25th, yes. Also, okay. Your Honor, could we, since we have this stipulated dispute here, can we push out the date for the due dates for the closing arguments?
Let's address that on the 25th. That way we have a better idea of how much more time we will need or less time.
Okay.
Because if it ends up going that, oh, well, it's not stipulated at all, and we're going to have a trial, that's going to radically change things. Let's see where we're at on the 25th at the end of that hearing.
Okay.
And Your Honor, will you send us, or your clerk send us a like a video link like this, or how do we do that?
Sure will. It's the same one. So
it's the same
just
one.
use the same one, please. Yeah.
All right. Excellent. Thank you.
All right. Thank you, everybody. And we will see you on the 25th. So at this point, I'm not going to be issuing an order, correct? I mean, is anyone expecting something from me?
I don't think so. I think we agree that we're just going to include everything in the closing arguments except for the affirmative defense, the first affirmative defense, which is.
And I understand there's going to be an amended answer sent in anyway.
Yeah, and you don't want an order denying the motion to strike, which is what I usually see. But if we did it all on the record, I guess it doesn't matter.
Yeah, go ahead and send an order like that. That's fine. And I'll sign that because at this point, Ms. Bong is correct that it's just going to be addressed in closing rather than as a strike, rather than the court striking any particular thing.
Okay.
Okay.
Well, I'll send that out. So thank you, Your Honor.
Fantastic. Thank you, everybody.
Thank you, Your Honor.
And we'll see you in a week.
Okay,
Bye-bye.